The training is really important, and consulting the experts and the professionals like attorneys, your insurance agent, your broker, risk management professionals, people who have our policy, our D&O policy, have access to a risk management helpline, which is free, 1 hour free of legal advice. So that's a great resource, a great tool. So if you have access to risk management professionals or you want to hire one, I highly recommend it. I think it's well worth the money and the investment and the time.
HOA Insights is brought to you by 5 companies that care about board members: Association Insights and Marketplace, Association Reserves, Community Financials, Kevin Davis Insurance Services, and the Inspectors of Election. You'll find links to their website and social media in the show notes.
Hi, I'm Kevin Davis of Kevin Davis Insurance Services.
And I'm Sherry Branson of Kevin Davis Insurance Services. And this is HOA Insights, where we promote common sense
for common areas. Welcome to episode 158, where we're again speaking with Sherry Branson, my co-host for my own monthly webinars at Kevin Davis Insurance Services. Hi, Sherry.
Hi, Kevin. Thanks for having me today.
Yeah, welcome back. Welcome back. So this is actually a follow-up episode of 153 where we talk about no decisions, and we discuss the dangers of not making a decision and how no decision is actually a decision. Today we're discussing the costs associated with no decision or a poor decision. Now, if you missed that episode or any other prior episode, take a moment after today's program to listen from our podcast website, www.hoainsights.org, or watch on our YouTube channel. Better yet, subscribe from any of our major podcast platforms so you don't miss any future episodes. Now, those of you watching from our YouTube channel can see that our HOA Insights mug I have from our merch store. Yes, we have a merch store. Visit our HOAinsights.org website or link to any show notes, and you too can get one of these things. Sherry, have you gotten yours yet?
I haven't got mine yet, but I'll have to call Robert. I keep forgetting to call Robert, but I will call him.
All right, you got to give him a call because we have a merch store and you get lots of stuff in there. We have some free things in there like board member Zoom backgrounds and some specialty items like the mug, okay, for sale. Now, we enjoy hearing from you, responding to issues that you are facing at your community association. So you have a hot topic, crazy story, or question you'd like for us to address, you can contact us at 805-203-3130 or email us at podcast@reservestudy.com. So Sherry, we're back again and we're talking about a topic we just talked about in my webinar just, a few days ago.
Yes, Kevin, very recently. This is a fresh topic, and we talked about claims that we saw in 2025 and trends that are happening, and the fact that there's, when boards don't make a decision, a simple claim can be very costly.
And that's the key thing. That's what we're going to talk about today. We talked about last time, a month ago, how just there's dangers between not make a decision in terms of just the overall appearance of the community association, the way it looks, the maintenance of it, collecting assessments. But today is a cost associated with it. And we're talking about the simplest of simplest claims. Okay, not complicated claims. We're talking about me as a unit owner, Sherry, you as a unit owner saying, I don't like what the board has done. They treated me unfairly. They're inconsistent. They didn't hear me. And they take a simple thing. And guess how much the cost of a simple claim is? $17,800, so it's less than $20,000.
Yeah. And Kevin, we've talked about the fact before that, claims, most of the claims that you see in community associations are not about money, but they do end up costing money in the end. But they're very emotional. It's regarding the flag, flying the flag, or parking in a spot, or I want to paint my house an unusual color, or plant a special tree in the front yard, and they don't approve of the tree, that kind of a thing. So they're very emotional claims.
That's a great point you're saying, because most of these claims are procedural claims, meaning that, guess what? The board did not allow me to do something I wanted to do. In other words, I want to paint my house a certain color, and they didn't allow me to do it. Okay? They didn't say no. They made no decision at all. So I went and started painting my house. Now, eventually what happens, they come back to me and say, well, guess what? It was not approved. Now all of a sudden I'm upset.
You spent money.
I did the work, So the delay that they made ended up costing me. Now I get a lawyer. because they made no decision, and I'm upset with them. And now all of a sudden the judge got to come back and say, guess what? Yes or no. And I get to keep my painted house, or I have to repaint it or do something else. So these are kind of decisions, pets, parking, these are the simple decisions that the board has to make a decision as outlined in the governing documents. And that's the key thing. When they don't make decisions as outlined in the governing documents or state law or whatever they have, then guess what happens? Now all of a sudden you face what you call a procedural lawsuit against you. Perfect example. Here's one that I love talking about, the trash can, right? The 48-hour trash can.
Oh, yes, those trash cans. Yeah.
I mean, for where you live at, where I used to live at, grew up, if trash cans not removed in a certain length of time, I'd knock on the door, take the trash cans back myself. And today, guess what happened? They end up going to the board and say, guess what, board, you need to fine this individual because his trash cans were out more than 48 hours. So now it's been 3 or 4 days. I want you to send out a fine, a notice of fine. So when you do that, now you have a person there who sits back there and gets upset because guess what? You're inconsistent in your rules enforcement. Because I see a lot of trash cans out there that's been there for 3, 4, a week long, and now you're going after me. So because you're inconsistent, now all of a sudden there is a claim made against you. Again, these are procedural claims. These are basic claims that the board has to follow. Again, these are documents that's outlined that, okay, you live in a community association. If you have an election, you have to notify people within maybe 30 days. Okay. But what happens if it's been, 45 days and you haven't sent out the documentation? We have people in that community association. This community association says, guess what? What you're doing is unfair. What you're doing is inappropriate. Therefore, I'm going to file a claim against you to make sure you do things in a more timely manner.
And the sad part of these procedural claims, Kevin, and like you said, small claims, is the people were never looking for money. They were not looking to sue or file a claim or to get money, but it does end up costing the association thousands of dollars.
$1,000. And it's the key thing to it. The reason why it costs so much money, because once you get a lawyer involved and a lawyer looking at procedures, if lawyers looking at the fact that, wait a minute, it's been 30 days or 4 days your trash can's been out, you're now not conforming to the governing documents. Your document says you have to have these things done over a certain length of time. If you don't have it, then that attorney who's handling that case is looking forward to it, because most states have what's called prevailing party fees. And basically that means is that if I win the case, I win back my attorney fees so that I win, so I don't lose.
You didn't have to spend any money to file the claim. So that then the association is paying for their attorney fees.
Exactly. So the lawyer wins because the association failed to just conform to the governing documents. So these are small procedural claims that we see constantly. And guess what? These kind of claims can be stopped.
What would you advise, the board members listening today, Kevin, what is the best way to handle this to stop it? What do you recommend?
The number one reason that a lot of these things happen, these procedural claims, is because the board failed to communicate properly. Okay? Communication is the key. They either ignore it, okay, afraid of it, or say that it's that crazy guy in unit number 6 again. He always complains about everything, okay? But what they don't do, they do not respond. Or if they respond, they don't do it in a timely manner.
So no decision or a delayed decision.
Exactly. And when you have that delayed decision, now all of a sudden, as you said before, it becomes emotional. And as it becomes more emotional, guess what happens? Now all of a sudden it gets more and more intense. Yes.
And more expensive.
That's the point. See, right now we're talking about $20,000 claims, basically $20,000 or less. Okay. Now we get a point though when we get past that $20,000 and hit that $100,000 to $250,000 range. That's where things, as you just said, starts to escalate. That's the problem that we see today, because we're living in a time where we have community associations and we have people who live there that are not, they don't like each other.
Unfortunately, yeah. more people at home and there's a lot more stress and, and things. And it just ends up turning into a lot of claims because there's, houses are closer together. You have shared walls in condos, that kind of a thing, noise.
And we live in that post-COVID world where right now here is what, 2 o'clock in the afternoon where you're at. Okay. It's 11 o'clock here and the landscaper coming in and you can't hear it, but I'm hearing it.
Back and forth. Yeah.
Exactly. So now if I live in a condo and it's this time and I hear pickleball people, pickleball noises, I hear the dog barking because he had a COVID pet. So we're living in a time now where things are heightened. And because they're hiding, I don't like the fact that the board is not listening to me. They're not responding. So it gets heightened when I'm saying, guess what? I don't agree with decisions you made. That's the $20,000 claim. But now I disagree with the decision you made. I think the decision you made is inappropriate. It's unlawful. You lack the authority to do it.
Okay. So now it's gotten to that point where it's contentious, where it's very contentious and, lawyers are billing more hours. They're getting more involved. They're filing more paperwork. So the costs are going up and up.
That's the problem. So the biggest problem, our fear, again, we're handling insurance for directors and officers of community associations. Our goal is, first of all, is to eliminate that $20,000 claim. And we do that by doing one thing, is communicate better. If you communicate better, guess what happens? You do not have those $20,000 claims. Okay. But now comes the next area. Now that only you haven't done your job of communicating properly, okay, you heighten the situation because the person on the other end lives in a community association where they are seeing things that haven't been done well. They've seen things that haven't been kept up. Whenever I start these community association talks, we talk about the board of directors have a basic job. They do 3 things. They enforce the rules, they collect assessments, and they maintain the association. So what you want to see is somebody being upset by one of those 3 things, or maybe all 3 of those things. So what happens now, if you have a situation where I'm upset because I failed to pay my assessment in a timely manner, I send them a nice note. They didn't respond to my note, and I keep getting fees. Now all of a sudden, I'm on the phone with my lawyer because guess what? You're being unreasonable.
We're targeting you with fees and fines and letters, and you feel discriminated against and they're picking on you.
That's the next word. So all of a sudden, again, we went from a $20,000 claim. Now we're into the $100,000 to $200,000 claim. That $100,000, $200,000 claim happened because you, as a board member, did not respond to me. It could be about the money. It could be about maintenance. It could be about the rules.
Right.
You would pass a special assessment where, guess what? I told you that the balcony that you said was cosmetic damage that was done, it was structural damage. I've been looking at this for the past 2 years. You didn't listen to me. Now, all of a sudden, you want a special assessment. Special assess me for $10,000 after you failed to do your job appropriately. So now, all of a sudden, guess what you have? You have a bigger claim. You have a claim that's gone from something really very, very small to something very, very big. Because what happens is, again, once you get to that point where I'm excited or I'm upset or I'm emotionally charged with it, now all of a sudden more money is involved. So you went from a $20,000 case to now, because of my emotions, my lawyer is now more involved because I'm upset because of special assessment. Right? So now that lawyer has to go out and do his job and find out, well, guess what? Did the association have the right to have a special assessment? Did he have the authority to write the special assessment? Because I'm saying the board lacked the authority to do it.
So it went from mild emotions to mildly upset to very upset. And since the temperature has gone so far up now, the price is going up, the lawyer's more involved, more legal fees, that kind of a thing. So everything has gone up. And it could have like you said, it could have been stopped in the beginning. It could have been stopped in the very beginning.
And the question is this: how do you end something like this? How do you say, okay, guess what? Everybody go back to the corners, figure out. It is hard to, because you're looking at something that's really, really important to the person who lives there.
Right.
A special assessment.
Right.
Okay. But it could be, a parking situation, no matter what it is. It could be a pet. You know, I've had this pet. I I have a dog. Okay. Dog is over the weight restriction that the
Right.
board has said. I have a 35-pound dog. The weight restriction is 25 pounds. I believe that rule is unreasonable. I believe you are discriminating me because guess what? You inconsistently apply that rule. You're applying it to me. So all of a sudden now you take a small claim and you heightened it.
Mm-hmm. And now it's a medium getting bigger and bigger with no end in sight, really. No end in sight. To calm it all down or to solve it is going to be much more challenging and more complicated.
And it makes it more complicated because the board doesn't do the simple things they should be doing. Okay. Again, communicating effectively, asking experts. You know, the simple thing they can do is go out and hire an attorney and say, can you please look at this and respond to this for me? Don't
Right.
go to Chat
Right.
GPT and say
Right.
how the best respond because
Right.
Chat GPT is not a defensible position if you were in court.
Right, right. Yeah, they should speak to their attorneys, call a risk management professional or hire a risk management professional, somebody who knows how to navigate this, Kevin, without escalating it and to calm it down, to cool it down, and hopefully stop it, before it gets to an even higher level.
And that's the whole point there, Sherry, is that we have to calm down the people who are involved. Because right now you have the unit owners upset, believe they're being mistreated. Okay. But you have the board member there who's uncomfortable because guess what? They may not have enforced the rules the way they should have enforced the rules. So in other words, if I'm complaining about, me parking my car in the wrong spot or my dog or the balconies and they choose not to do anything about it, they now will defend themselves. Now, what they could do is step in early and resolve this thing in an early manner. Okay. Don't let it escalate. Don't let it get bigger and bigger and bigger. Try to have it, more manageable.
Absolutely, absolutely. But a lot of times, the board member may be defensive or not feel, they might want to dig their heels in and say, I'm going to defend myself and defend the association. But you're right. I think hiring somebody from the outside to come in, an attorney or risk management person, somebody who can help bring it down and handle it so that it's resolved in a way where everybody's happy, or at least reduce the heat and the emotions of it to the point where they just, like a mediator type person would be good.
And one word that I used last time when we talked about this a month, they have to learn, the board, if they can be just a little bit kinder to the people who bring in these things against them, they can avoid a $250,000 lawsuit. Okay, that's what we're talking about right now. We're talking
Right.
about $100,000 to $250,000 because the board of directors, okay, again, the unit owner there who lives there is complaining to the board because I don't like the decision you made, but the way you handle it was inappropriately. The way you handle it, I believe it was wrong. The way you handle it was unlawful.
Right.
It was unreasonable. When they start throwing out words like this, you lack the authority. Now I'm challenging the board. Once I challenge that board, we're not talking about $20,000 anymore. We're talking about $100,000, $200,000. I'm challenging the board's authority to act.
Yeah, Kevin, where people receive a letter in the mail saying, you have to do this to your lawn, or you have to take that flag down, or you have to stop painting your house. I know you're in the middle of it, but rather than having board members talk, maybe have a meeting with the homeowner, and saying, I understand this is not a popular decision, or, sorry, I have to tell you this, but, there's ways to handle things with a letter, just a cold letter saying, I'm sending you a $50 fine over your trash cans, you know what I mean? As opposed to, just talking to the person and saying, hey, I'll let it go this time. You just want to let you know that the rule is, I know it's a pain, but, you have to have the cans in 48 hours and, something like that.
And that's what I always say is about this as board of directors of community associations is your job to kind of lower the temperature so you don't end up with a $20,000 claim, let alone when that $20,000 escalates to a $200,000 claim. And it's easy for it to happen. It's easy. All you have to do is say, you're being unreasonable. Okay? You don't have the authority. Now, all of a sudden, you take it that much bigger. And all you have to start by doing is communicating effectively, but communicating in a kindly way. Communicating in a kindly way, it'll allow you that ability to be able to handle things a lot better.
Absolutely. That's the key, I think. And I think, it's nice. Every HOA has to have rules. Everybody knows that. But there are ways, I think, in some situations to communicate them where you can understand that a homeowner would be upset about a pet if you're telling them they can't have their pet anymore or paint the house their favorite color or whatever. These are, like we said, they're emotional decisions and emotional claims. So I think handling it with some discretion and kindness and communication, I think, goes a long way and could save the association a lot of money, and everybody wouldn't be so stressed out. It wouldn't get worse, put it that way.
And you're right, too, in terms of all these decisions are mostly emotionally based, which at the
Yeah.
end of the day, which means that once it goes to a judge, right, the judge is sitting there. In most of these cases, they'll say, okay, I understand. You don't like the election. You don't like the fact that your car was towed. You don't like the fact you can't have a pet. Well, how were you harmed financially? So what kind of judgments? What do you want as a
Right.
result of this?
They don't want money. That's the thing. They don't want the money. They want to be able to keep the pet.
And that's the whole point. So a lot of times when we talk about these lawsuits that end up costing $20,000 or go from $100,000 to $250,000 to almost $500 million, you're talking about defense costs. It's rare where there's a judgment, settlement, damages involved.
Yeah. So just such a unique situation that, the board members, I don't think, realize, that they're in. And I think that if you have people skills and communication skills and maybe, take some training, some courses regarding that, maybe mediation skills would be a good class to take. Just something like that would really go a long way in saving everybody a lot of headaches and a lot of money.
How true. All right, Sharon, listen, it's break time. Let's take a break and hear from one of our sponsors. Then we'll come back and talk about big $1 million claims, how we get them, and how we stop that from happening, okay? Let's take a quick break. Hi, I'm Kevin Davis, the president of Kevin Davis Insurance Services. Our experienced team of underwriters will help you when you get that declination. We provide the voice of reason, someone who will stand by you. Our underwriters bring years of knowledge to our clients that can't be automated by technology or driven by price. As a proud Anwins company, we bring true value to your community association clients. We are your community association insurance experts. And we're back. Let's talk about the big claims. $1 million claim. Last year we had a $3 million claim. Okay.
Yes, that's incredible. That's
claim.
the biggest one that Kevin Davis Insurance has ever had, correct?
Biggest one they ever had. Let's talk about how you're going to see a large claim. Okay. A large claim happens in about a couple areas. Number one, structural damage. Like the one I talked about with the balcony. In California, you have balcony laws that you have to have a balcony inspected. Again, what happened to the one we're talking about? They thought it was cosmetic, it's structural damage. And when you have structural damage, we have a $1 million claim. It is no longer about me. It's about the association in general. That's the difference.
Right,
okay?
right.
$20,000 claim is about me. $100,000 claim is about me. $1 million claim, it's not just about me. It's everybody who lives here.
Right, right. That's an extremely expensive claim.
Expensive
one
claim.
that will go on for years, right, Kevin?
8 years, 8, 10, 12 years, $1 million claim occurs. Number one reason, structural. That's the big reason why. Second reason is really we have our severe weather. So they kind of go hand in hand, but when we had the wildfires out here last year, a year ago, the amount of claims that we are seeing today is unbelievable. We're starting to see claims from them because the board of directors were not prepared for this. They didn't do the proper notifications. They didn't have a manual that tells them what they do in the event of a major disaster. We've seen it with fires. We saw it with the earthquake we had in California. We saw it with wind damage. Whenever there's a major disaster, we're looking at $1 million claim. Oh, the main one that went down, the one in Florida, Surfside.
Surfside. Yeah, Surfside. That's structural. I mean, that was the board member. They had done this study, right? They had the engineering study. They had had the building inspected. They knew the work needed to be done, Kevin, and they had the money. They had the money sitting in the account. They delayed it and delayed it and delayed it. And, you and I have talked before about, a lot of board members, they don't want to be the ones to say, oh, we have to pass a $10,000 special assessment. We all have to fix the parking garage or the foundation or the roof or something. And they don't want to be the bad guys. They don't want to deliver the bad news, So they don't make that decision. They don't pass the special assessment and don't spend the money, even though they have it.
And guess what? Money's the next big one. Next big area is, we talk $1 million claim is money. We're talking about fraud. We're talking about embezzlement. We're talking about mismanagement. Because we're talking about a special assessment of millions of dollars. There's always somebody who's going to say, guess what? You did not handle it properly. A reserve study told you 10 years ago, 5 years ago, that you needed X number of dollars. You didn't do it. So therefore, again, it doesn't just impact me, but it impacts the entire association. So we're going to hold you board members responsible for that special assessment or for the lack of money we need to make the appropriate repairs. Again, another large claim.
Yeah.
Structural damage, financial, severe weather. The next biggest one we're talking about is discrimination. Discrimination is a big one. Discrimination is a big one in community associations because a lot of times most people don't realize they're discriminating until they go look and go, oh, guess what? The only person that hasn't been impacted was, guess what? A person of protected class. The only person that we end up repairing the roofs on everybody, but we left one person out. Now, the reason why we let that person out is not because we discriminated against them, because they happen to be the person that we don't like in the association.
And you don't like that person, so you're going to, exactly, single that person out because you don't like them. You know what I mean? And emotional. These things are all emotional. The board members, they live in the association. They know their neighbors. They have, they know who the complainers are, the people who complain all the time. And
And what happens is now, we found out a couple of times when the judge comes in and says, guess what? Yes, you did discriminate against that one individual. You have to buy their place. You have to buy their place.
Right.
So you end up now, all of a sudden, you have, again, a huge, it could be a $500,000 home. You're talking about the defense and everything that we had to be a part of in this one claim. So now you're in that $1 million zone, that $1 million zone, that $2 million loan, a $3 million loan.
Kevin, I know the $3 million claim that we saw, discrimination was part of that one, right?
It was a discrimination case, and it was from a massive hurricane wind damage in Florida, where the person, we started receiving monies to repair the community association, and one person was left out, and that one person had to be a protected class. Now, yes.
Oh.
Now, when you do the work and we did the research, you find out the reason why a person left out, it was just a going back and forth. There's communication issues. There's a problem with it. The person wanted more than they were entitled to, and they're going back and forth, but it had to be a protected class. And what happened in a protected class, you end up, it just, you add it all up, and it ended up being a major, major deal for this one situation.
Wow. Yeah, $3 million. That's a huge claim.
And then the final area is just a major breach of fiduciary duty. The board breached of fiduciary duty because they failed to inspect this one unit. They failed to inspect it. Because again, by law, you have to do either, like in Florida, you have structural integrity laws. In California, you have laws. So in certain states, you have these laws. If you do not comply with these laws, so now all of a sudden, I can't sell my unit.
Right.
Okay? I can't sell my unit because Fannie Mae, Freddie Mac says, guess what? You're in the blacklist.
Right. Yeah,
So,
that's a huge problem right now. Mm-hmm.
it's a big
Can
problem.
you
So
explain what the blacklist is for people who might not be aware?
Fannie Mae and Freddie Mac has this list of associations that does not comply because of either the reserves are inadequate, they have structural issues, or they have insurance issues. One of those three usually are the problem. Well, what happened is the community association breached their fiduciary duty, major breach of fiduciary duty, because all of a sudden I can't sell my unit, but nobody else can either.
Yeah. So that's
So now all of a sudden you're talking about a claim that's impacting more than just me. When that happens is you're talking about $1 million claim. Because guess what happens now? My unit is not worth $500,000 anymore. It's only worth $400,000.
Right.
If I can sell it at all, because I can't get a Fannie Mae. Yeah, exactly.
Wow. And the sad thing about that is a lot of homeowners don't even know that their association is on the blacklist.
It's on the blacklist,
until they go to
right?
sell.
Until
they go to sell.
Yes, until they want to sell. And then all of a sudden, they find out the hard way. But again, the difference between the large cases, the large ones, is that it impacts more than just me.
Impacts everybody.
It impacts more people.
Mm-hmm.
So let's summarize what we learned today. Okay. Poor documentation, deferred maintenance, inadequate reserves. Okay. No decision or a bad decision all leads to losses. Costly losses. Okay, at the minimum, a little less than $20,000, but the maximum it can be in the millions of dollars. So, what association are you going to do about it? Number one, enforce rules consistently. Number two, communicate decisions clearly. Number three, address problems early. Number four, seek advice from the experts. And number five, board members should seek training. Get a little bit of education on how to run a board of directors.
It's a job, Kevin. It's a job. And training is so important. And, we've discussed it. You touched on it today. And when we've talked about in other webinars, you're following state laws, county laws, city laws, and federal laws. And as a board member, you're a volunteer. And you're not going to know all the laws and ordinances and requirements in that each particular area. So it's a lot to know.
It's a lot to know. Yes. So any closing comments there, Sherry? We got anything?
I just want to, piggyback on what you said, which is, the training is really important, and consulting the experts and the professionals like attorneys, your insurance agent, your broker, risk management professionals, people who have our policy, our D&O policy, have access to a risk management helpline, which is free, 1 hour free of legal advice. So that's a great resource, a great tool. So if you have access to risk management professionals or you want to hire one, I highly recommend it. I think it's well worth the money and the investment and the time.
I have one that we didn't say, and treat it as a business.
Mm-hmm. That's key. That is key.
Is it? You're running a multi-million-dollar corporation. Treat it as a multi-million-dollar corporation, not as a social club where you get to decide what books you're going to read or what Netflix show you're going to watch. You get it, treat it as a business. When you treat it as a business and you act as a business, if you get sued, and on those $20,000 claims, you have insurance to pick it up. What you don't want to do is to get that $20,000 claim into that $100,000 claim or $1 million claim. So the one thing we hope we did was give you some advice or some reasons or some ways to make sure you lower the temperature, be kind to one another, be kind in your communication so that we don't end up hearing about that $1 million claim on TV or in the newspaper. So anyway, thank you a lot, Sherry. I look forward to doing this again sometime in the future. I enjoyed doing it back to back with you.
Yes, I did too, Kevin. Thank you for having me today. I had a lot of fun. Thanks so much.
All right. Take care. Thank you very much.
You've been listening to HOA Insights, Common Sense for Common Areas. You can listen to the show on our podcast website, hoainsights.org, or subscribe on any of the most popular podcast platforms. You can also watch the show on our YouTube channel. Check the show notes for helpful links. If you like the show and want to support the work we do, you can do so in a number of ways. The most important thing you can do is engage in the conversation. Leave a question in the comments section on our YouTube video. You can also email your questions or voice memos to podcast@hoainsights.org or leave us a voicemail at 805-203-3130. If you gain any insights from the show, please do us a huge favor by sharing the show with other board members you know. You can also support us by supporting the brands that sponsor this program. Please remember that the views and opinions expressed by the podcast do not constitute legal advice. You'll want to consult your own legal counsel before making any important decisions. Finally, this podcast was expertly mixed and mastered by Stokelight Video and Marketing. With Stokelight on your team, you'll reach more customers with marketing expertise that inspires action. See the show notes to connect with Stokelight.